Hello my friends, I've been thinking, should people be allowed to try and legislate laws using moral principles based on religious reasons? People have tried to legislate laws they believe would benefit society. However, a lot of Americans are concerned of religious institutions taking over the government and legislating religious laws. But do not fear. Why? Because we have a separation of church and state.
Separate church and state.
The separation of church and state.
The separation of church and state.
The separation of church and state.
Separation between church and state.
Separation of church and state.
Separation of church and state.
You have probably heard the phrase repeated on the news, social media, or podcasts. Unfortunately, many people in the United States, regardless of where they land on the political spectrum, do not know where this concept came from, nor do they have a firm understanding as to why it was said in the first place and what it means for us today. Some of you probably think that this means that the government is not allowed to compel churches to follow general laws, or that churches are not allowed to participate in political matters, or that the government cannot institute legal requirements for churches, or that churches cannot use government funding. None of these are true. Although some of you may hold opinions to the contrary, it needs to be made clear that they are not true for two reasons. One being the First Amendment, and the second being the Supreme Court's interpretation of its purpose considering historical context. Before we understand what the separation of church and state means for us today, we're going to review the history of where this concept came from and how it evolved for over more than 200 years. Are you ready? We begin as far back as 1607, when the colony of Virginia was founded, during which time many European settlers brought the faith of their respective national churches with them. However, in 1619, the Virginia General Assembly established the Church of London as its official religion. Virginia's government passed laws requiring clergy to instruct citizens on how to receive the Eucharist, penalized the violation of certain scriptural laws, and required ministers to keep records of baptisms, marriages, and deaths for the government's use. Over the course of the next 150 years, the state-established Church of England gained more power and influence through the government's legislation, which restrained the development of other churches, discriminating and persecuting dissenters of the Church of England, most of whom were Presbyterians and Baptists, and led to only one religious institution controlling the entire colony of Virginia. It was only until the American Revolution started when the Church of England began to lose its government-sponsored power. In 1776, the Virginia General Assembly appointed a committee of revisers to review the existing laws, which at the time were sympathetic to King George of England, and to draft up new legislation for an independent state of Virginia. One of the revisers on this committee was Thomas Jefferson, who in 1779 presented 126 new bills to the General Assembly of Virginia for review. Many of these proposed laws were accepted in 1786, one of them being Bill 82, titled A Bill for Establishing Religious Freedom. Thomas Jefferson's understanding of religious freedom can be seen within this statute, in which he affirms that Almighty God created the human mind to be free, and that the government is not allowed to force people to hold certain opinions or beliefs, and no person is to be compelled to be a member of or attend any church or to support it with taxes. Thus, an individual is free to worship with no discrimination. The statute also says that it is the people's right to change any law, thereby exercising their freedom of opinion using reason with the free mind that God gave them. It is in this way Jefferson showed the balance between the natural rights of the individual and the national sovereignty of the people. The bill later was called the Virginia Statute for Religious Freedom, and its fundamental principle would be the basis of the First Amendment. In 1791, the Bill of Rights, the first 10 amendments of the Constitution, were ratified. The First Amendment begins thusly: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Because of this, government is not allowed to establish a national or state religion. Rather, people are free to exercise their beliefs. But does this mean the government can depose of or persecute religious institutions? And can individuals exercise their beliefs to the extent that it violates general laws? These concerns are answered by Jefferson himself in a letter responding to the Danbury Baptists of Connecticut. During the 1790s, many minority faith churches, such as the Baptists, were concerned that the majority faith church, which at the time was the Congregationalists, would lead the government to establish Congregationalism as the official religion. Remember, the First Amendment was ratified in 1791. 10 years later, in 1801, the Danbury Baptist Association wrote a letter to then-President Thomas Jefferson regarding their concern over government overreach into religion, writing that no man ought to suffer in name, person, or effects on account of his religious opinions, that the legitimate power of civil government extends no further than to punish the man who works ill to his neighbor. In 1802, President Thomas Jefferson responds, "Believing with you that religion is a matter which lies solely between man and his God, that he owes account to none other for his faith or his worship, that the legitimate powers of government reach actions only and not opinions, I contemplate with sovereign reverence that act of the whole American people, which declared that their legislature should make no law respecting an establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state." Here you have the origin behind the concept of the separation between church and state. Jefferson reassured the Danbury Baptists that their freedom to believe in their religion will not be impacted by the state. The government is not allowed to force people what opinions or religion to hold, but the government can affect actions such as punishing individuals for violating general laws. Before we move on, I believe we need to ask a very important question. What is the purpose of laws? In the simplest of terms, laws are for protecting that which is morally good, such as the rights of people. Laws are also for punishing that which is morally bad, such as actions that violate the rights of people. Laws are the legislation of moral values. Legislatures are elected to reflect the moral principles upheld by their constituents. For example, most people agree that people have a right to life as life is a moral good, and since murder is a violation of that moral good, the people would elect a political leader who would make murder illegal. Returning back on topic, what many people fail to realize is that within that same letter Jefferson wrote, "My duties dictate a faithful and zealous pursuit of the interests of my constituents, and in proportion as they are persuaded of my fidelity to those duties, the discharge of them becomes more and more pleasing." The vast majority of Jefferson's constituents were Christians, whom he helped promote their interests by legislating their moral principles stemming from their Christian faith. It was also in Thomas Jefferson's first inaugural address in 1801 in which he described to the people how he would operate as President of the United States of America. Entertaining a due sense of our equal right to the use of our own faculties, enlightened by a benign religion, acknowledging and adoring and overruling providence, what more is necessary to make us a happy and a prosperous people? With an admittance of the overruling power of the same creator Jefferson credited humanity's rights to in his Declaration of Independence, Jefferson closed his address, "And may that infinite power which rules the destinies of the universe lead our counsels to what is best, and give them a favorable issue for your peace and prosperity." Jefferson assured that the state would not directly control the institution of the church, nor would the church institutionally control the state. But Jefferson admitted and supported the fact that the moral principles and values of his supporters, most of whom were Christians, would be the basis of the state's legislation. No religious institution would nor should control the state, but the people working in the state, guided by their own religious values and reflecting the religious principles of those who voted them into office, can and would legislate laws based on their moral principles. But doesn't that contradict the whole separation between church and state? We'll come back to that point right after we quickly browse through some important Supreme Court cases on the matter. 1878, Reynolds versus United States. George Reynolds, a member of the Church of Jesus Christ of Latter-day Saints, also known as Mormons, was convicted of violating federal law for practicing polygamy. Reynolds challenged his conviction on the grounds the First Amendment protected his right to practice polygamy, as he argued that it was part of his religious exercise. The Supreme Court ruled against Reynolds, affirming that even though religious belief was protected under the First Amendment, religious practices could be restricted if they violated general laws. In this case, the general law forbade polygamy. Chief Justice Morrison Waite, who wrote the majority opinion, stated, "Laws are made for the government of actions, and while they cannot interfere with mere religious beliefs and opinions, they may with practices." He said that while the government could not restrict one's belief of opinion on the matter of polygamy, it could regulate practices like polygamy that were deemed to be harmful to society or in violation of the law. Reynolds versus United States established a crucial precedent in the interpretation of religious freedom under the First Amendment. The case clarified that the government could regulate religious practices that conflicted with public morals or laws, thus drawing a line between belief and practice, or opinion and action. 1947, Everson versus Board of Education. There was a law in New Jersey that allowed local school districts to provide public transportation of children to and from schools. The Ewing Township Board of Education authorized parents to receive reimbursement for the cost of public transportation of their children to and from public and private schools, which included religious schools. One taxpayer, Thomas Jefferson, sued the Board of Education stating A, that providing reimbursement for public transportation to and from private religious schools violated the Establishment Clause of the First Amendment, and B, that using taxpayer funds for this violated the Due Process Clause of the 14th Amendment. Once this reached the Supreme Court, the decision came down to 5-4 vote, upholding New Jersey's state law, allowing parents to continue receiving reimbursement to public transportation for all students to and from accredited schools. In a majority opinion by Justice Hugo Black, the Supreme Court reasoned that New Jersey's law was constitutional because the law had a public purpose, that being to provide transportation for all school students, and that the state's law was not respecting an establishment of religion. It was Justice Hugo Black who popularized the words of Thomas Jefferson, saying, "The First Amendment has erected a wall between church and state. That wall must be kept high and impregnable." This was the first major case applying the Establishment Clause to the states through the 14th Amendment, as well as adopting Jefferson's wall of separation metaphor. 1948, McCollum versus Board of Education. Illinois state law required parents to send their children to its tax-supported public schools. In Champaign City, a voluntary association called the Champaign Council on Religious Education, formed by Protestants, Catholics, and Jews, received permission from the Board of Education to offer religious classes during school days in public school. The religious teachers were not paid by the school, and participation was voluntary, but the program was conducted within the public school system. Vashti McCollum, a Champaign resident and tax-paying parent, sued the Board of Education, arguing that this violated the Establishment Clause of the First Amendment. The U.S. Supreme Court, in an 8-1 decision, ruled that the program was unconstitutional. The court held that using tax-supported public school facilities for religious instruction violated the Establishment Clause, which applies to the states through the 14th Amendment. Justice Hugo Black stated in his majority opinion, "This is beyond all question a utilization of the tax-established and tax-supported public school system to aid religious groups to spread their faith." This decision was a legal landmark in that it set a clear precedent that the public schools cannot promote or facilitate religious instruction. 1962, Engel versus Vitale. A New York public school had students recite a state-written prayer. This was ruled unconstitutional because even though the prayer was voluntary and non-denominational, prayer that is supported by public schools violates the Establishment Clause of the First Amendment. This decision reinforced the idea that government and public schools cannot promote or sponsor religious activities. 1971, Lemon versus Kurtzman. Pennsylvania and Rhode Island laws allowed state funds to provide financial support to private schools, which included religious schools, by reimbursing the cost of teachers' salaries under certain conditions. The Supreme Court, in a vote of 8-1, struck down those laws, concluding that allowing public money to support private schools, some of them being religious, violated the Establishment Clause of the First Amendment and the Due Process Clause of the 14th Amendment. This case introduced the Lemon Test, which helped evaluate if the church and state became mixed up too much. The Lemon Test consists of 3 assessments. First, the law must have a non-religious purpose. Second, its primary effect must neither advance nor inhibit religion. And third, it must not result in excessive government entanglement with religion. This case, though it made the intention of the wall of separation clearer, made judges realize that the application of this principle may prove difficult to uphold and define as time passes, causing Justice Warren Burger to say, "The line of separation, far from being a wall, is a blurred, indistinct, and variable barrier." 1992, Lee versus Wiseman. A public school in Providence, Rhode Island invited a Jewish rabbi, Robert E. Lee, to give a prayer at graduation. One of the students' parents, Daniel Weisman, filed a motion against the Jewish rabbi. Once this case was brought to the Supreme Court, it ended in a 5-4 vote. The Supreme Court determined the prayer to have been unconstitutional as it caused students to be subtly coerced into participating in a religious exercise. This shows that the government or any public institution cannot directly involve people into religious ceremonies as it violates the Establishment Clause of the First Amendment. 2014, Town of Greece versus Galloway. The town of Greece allowed volunteer chaplains to open their council meetings with a prayer. Susan Galloway and Linda Stevens, represented by Americans United for Separation of Church and State, argued that those prayers violated the Establishment Clause of the First Amendment. In a 5-4 vote, the Supreme Court ruled that the practice of opening prayer in town meetings was constitutional, so long as the practice is not coercive and allows diverse religious voices. Justice Anthony Kennedy wrote in his majority opinion, Greece neither reviewed the prayers in advance of the meetings nor provided guidance as to their tone or content, in the belief that exercising any degree of control over the prayers would infringe both the free exercise and speech rights of the ministers. To hold that invocations must be non-sectarian would force the legislatures that sponsor prayers and the courts that are asked to decide these cases to act as supervisors and censors of religious speech, a rule that would involve government in religious matters to a far greater degree than is the case. Elena Kagan, one of the minority justices who voted against prayer in council meetings, wrote hypothetical situations in her dissenting opinion that were not accurate to the facts of the case, and painted a false picture of the circumstances of the prayer. This led Justice Samuel Alito, one of the majority justices in this case, to write in his concurring opinion, "This brings me to my final point. I am troubled by the message that some readers may take from the principled dissent's rhetoric and its highly imaginative hypotheticals. For example, the principled dissent conjures up the image of a litigant awaiting trial who is asked by the presiding judge to rise for a Christian prayer, of an official at a polling place who conveys the expectation that citizens wishing to vote make the sign of the cross before casting their ballots, and of an immigrant seeking naturalization who is asked to bow her head and recite a Christian prayer. Although I do not suggest that the implication is intentional, I am concerned that at least some readers will take these hypotheticals as a warning that this is where today's decision leads, to a country to which religious minorities are denied the equal benefits of citizenship. This case shows that individuals may exercise their freedom of religion through their freedom of speech on public property during public meetings if they are given permission for time and the participants are not forced to experience it. 2022, Kennedy versus Bremerton School District. In Bremerton, Washington, public school football coach Joseph Kennedy would pray on the field after each game. The school board determined Kennedy's actions violated the Establishment Clause of the First Amendment and decided not to renew their contract with the coach. Kennedy sued the school board for violating his right to free speech and free exercise of religion. The Supreme Court ruled 6-3 in favor of the coach, stating that his actions were private religious expression protected under the Free Exercise Clause of the First Amendment. Justice Neil Gorsuch, in his majority opinion, wrote, "We are aware of no historically sound understanding of the Establishment Clause that begins to make it necessary for government to be hostile to religion in this way." Gorsuch also writes, "The Constitution neither mandates nor tolerates that kind of discrimination." After going over Thomas Jefferson's writings and the explanations in his own words, as well as seeing how the Supreme Court interpreted Jefferson's wall of separation over the course of 200 years, we can begin to understand that separation of church and state means 4 things. Number 1, limiting government interference in religion by guarding against laws that would restrict individuals' rights to freely practice their religion, so long as those religious practices do not infringe on the rights of others nor violate general laws. Number 2, limiting religious interference in government by preventing religious institutions from controlling government policies or laws. Number 3, protecting the individual's religious freedom by ensuring that the government does not establish a national religion or favor one religion over another. Number 4, protecting the individual's political freedom by ensuring that the government does not restrict the individual's right to try to change laws that would align with their opinions, even if those opinions are based on religious beliefs. Remember, politics is about legislating ideas that are upheld by moral principles. Anytime someone wants to legislate a law, we can assume they do so in the pursuit of a moral good, supposing the moral good was the goal and not towards some greedy or selfish byproduct, as it may be the case with some laws such as, for example, those relating to insider information and stock trading. Many people think that morals ought to be founded upon secularism. However, secular moral virtue is an oxymoron. Morality cannot be founded upon secularism, as the legislative fight will inevitably and immediately degrade into unsubstantiated personal opinions. One person will fight against any and all abortion, while another fights for the right to murder babies after they are born. One person will fight to make all drugs illegal, while another person fights for the legalization of fentanyl. Within secular society, the core of every person's argument boils down to personal preference and biased desire using reason as a facade. Reason, unless it be upheld by an eternal mind, which is the position Thomas Jefferson held, is worth nothing to humanity. A secular position holds absolutely no moral justification. People who say that morality is justified by the common agreement of a society don't realize that they are providing the very justification that child-sacrificing indigenous American tribes, German Nazis, and the authoritarian Chinese Communist Party used to commit their atrocities. The Nuremberg trials is evidence showing the idea that society determines morality is not true. Just because a society decides action XYZ is moral does not make it so. Morality must originate from an eternal source. Otherwise, no human being is justified to judge the actions of another. The secular worldview has absolutely no ground, no capacity, nor argument to justify the idea that a human life is worth more than the life of an amoeba. Any secular person arguing so is simply claiming themselves to be the de facto God judge of the universe. Though our understanding of morality can be limited by our incomplete knowledge of the eternal mind, and our rationality may be nuanced in difficult circumstances, either morality is eternal and objective, or it's not. In which case, it is pointless to even argue which law is moral and which law isn't, which rule is good and which rule isn't, which statute is reasonable and which statute isn't. In secular society, it all comes down to who can enforce their opinions with greater violence, and the worst part is that at the end of the day, no one is morally correct or incorrect, as there wouldn't be an ultimate foundation for morality. It is because of this reason, Christians, not to be confused with Christian institutions, but Christian individuals should use their God-given rights to engage in politics to lead the fight in advocating for and protecting the peace and prosperity of the people. As Thomas Jefferson wrote, "And may that infinite power which rules the destinies of the universe lead our counsels to what is best and give them a favorable issue for your peace and prosperity." It is good that religious institutions cannot control the government, and it is even better that people guided by their moral principles can. I leave you with the following words of one of our founding fathers, Patrick Henry. "Besides, sir, we shall not fight our battles alone. There is a just God who presides over the destinies of nations, and who will raise up friends who will fight our battles for us. The battle, sir, is not to the strong alone. It is to the vigilant, the active, the brave. Our brethren are already in the field. Why stand we here idle? What is it gentlemen wish? What would they have? Is life so dear or peace so sweet as to be purchased at the price of chains and slavery? Forbid it, Almighty God. I know not what course others may take, but as for me, give me liberty or give me death." I hope this information helped you learn that it is precisely the separation of church and state which gives Christians the ability to legislate Christian values in the United States of America for the benefit of the American people. The following is a short list of materials that I invite you to read. They show how our American forefathers intended the American people and their governing leaders to be guided by the moral virtues and principles of reason set forth by Almighty God. Here's a fun question. If you had the power to legislate up to 5 laws in your country or state, what would they be and why? Let me know in the comments. Thank you.